We are very lucky to have some attorneys from over at Gibbs joining us on this webinar. We know that everybody has a lot of questions about how the coronavirus pandemic is affecting construction and affecting your ability to get paid. So we're lucky to have some construction expert attorneys here that can give best practices and give some insight onto that. If you have questions during the webinar, feel free to type them into the chat or question and answer box that you see, and they will be addressed either immediately or during the end of the presentation, probably during the end. But with that being said, I'll kick it over to Chris, who can introduce the rest of his team over there. And thanks for joining us.
Thanks for having us, Nate and Justin. My name is Christopher Ng. I'm the managing partner of Gibbs Giddon. We are a Los Angeles-based construction law firm serving the entire state of California and the entire state of Nevada. We have a network of construction attorneys around the country through the American Bar Association Forum on Construction Law. Many of those members are part of the Levelset expert team around the country. And in this time, which is one of the most unprecedented things that's ever happened in probably human history, we're all sort of coming together to figure out how we move forward, how we protect ourselves, how we ensure our own livelihoods. So I have with me today two of my colleagues who are my partners, Sarah Kornblatt and Richard Whitbrodt. Collectively, we have about 75 years of, maybe longer, 80 years of experience in the construction world. We are construction lawyers, and we all have leadership positions within the American Bar Association Forum on Construction Law. And as you might imagine, we're all interconnected right now and speaking on a pretty much a daily basis, talking about the different issues that face us around the country when it comes to the coronavirus and construction. So today, just to give you a little bit of a roadmap, our initial idea was to do a 30-minute presentation. And we decided, because of quite literally the hundreds of emails we're getting every day and the phone calls, that we'll do our half hour, but we'll extend as long as we have questions. And I know there's a lot of you that are worried and concerned, and we're going to talk you through things that you can do to protect yourself, things that you need to look out for, things that you should be doing on your current projects that might be subject to shutdowns, suspensions, or terminations, what force majeure means, what do your contract documents tell about your situation and your rights, duties, and responsibilities. And then how we move forward to protect ourselves using your statutory rights, regardless of whatever state you're in. So I'm going to set the table a little bit just by recapping, and these slides are brand new as of this morning. And I know, again, most of you are following this on a daily, hourly basis. The coronavirus death toll is now 10,000, and the situation in the United States is unfortunately getting worse before it gets better. And when we say worse, you know, it's not perhaps that more people have coronavirus, it's just, of course, that we're getting better at testing. When we get better at testing, our numbers are skyrocketing. And because of that, and because of the highly contagious nature of the disease, we are taking drastic steps from a federal, state, and county and local level to try to curb this. Any of these slides, by the way, some of these are screenshots from CDC and other organizations, but these are all ones that I'm sure most of you are familiar with, about social distancing and how you can stay healthy yourself, things that are safe to do and things that you should be avoiding doing. And so again, the focus today is on the impact of coronavirus in our ongoing construction projects. Of course, if you Google the terms coronavirus and construction, you can spend all day with daily updates. ENR has a nice list of the latest headlines, and I won't say panic around the country, but definitely concern in pretty much every state. And it's really affecting some municipalities more than other. We know Boston, for instance, is shut down. To my friends over in Boston, the mayor of the city of Boston has shut down construction. And unfortunately, what was a booming market a month ago has come to a screeching halt, as the headline says. We haven't quite gotten there in other venues. Chicago, unfortunately, looks like it may be headed to something close to a Boston shutdown, but we're going to see. Dallas, I know, is concerned about what's happening. Florida is obviously taking it pretty hard right now, as is New York. There is some interesting headlines out there. You'll find a couple of days ago, Hawaii indicating that in some ways that they're going to let construction continue and go on. And so the impact may actually not impact them and let them continue to focus on infrastructure and other projects. So it is hitting us a little bit differently. Clearly, there are reasons why, because of the coronavirus, we're all going to be impacted. The first concern that we had, as we talked last week, was about the supply chain. And literally headlines and quotes from the largest contractors in the country are completely obsolete, 7 days later, because of how this has progressed. Still, the supply chain is a concern. China is getting back on its feet, as some of you know. But for sure, with 30% of our raw materials coming from those countries impacted, we are going to have delayed materials, delayed shipments, some which will impact the critical path, some which will not. We'll have price escalations and other issues. Clearly, the new wave of quarantines and shutdowns are impacting our ability for our workers to do on-site work, as we'll talk about in a minute. There's a 30,000-foot view as far as the economic and market challenges that clearly we're going to face. Lenders, owners, and contractors, their ability to get through and survive for the next couple of months as we push through and then figure out how we move these projects forward. And for those of you that are, and I know the majority of our audience here are contractors, there's some suppliers and mostly contractors here. Clearly, your concern, especially if you're a smaller contractor and if you're a larger contractor, is that the suspensions and terminations are going to impact you, impact your ability to make payroll, impact your ability to pay your folks, slow down your pay draw process. And so clearly this is having a major impact. And we know that as we move forward, when continued performance isn't possible, and it may come from the top with lenders, it may come from owners, it may come from the GCs that are working on those projects. There's going to be lots to talk about suspension and termination. So again, we're going to walk through sort of our top tips here about how to protect yourself and how to get paid on these projects. First and foremost, let me say that this can't go without really emphasizing that it's imperative that we all stay current on the COVID-19 public health orders. And if you're in a jurisdiction that really, it seems still far away, we have 10 cases, we've got 15 cases, here in Salt Lake, or we've got 6 cases in South Carolina. Oh, it's still on the horizon. I mean, that's what we thought in Los Angeles about 7 days ago. And as you may have heard last night, we are shut down. We are in a stay-at-home policy, except for essential business functions. So things can change rapidly. And so it is imperative for all of you to understand not just what the state and what the county, but also what the local government orders are that pertain to your projects. It's very important to see what the edicts are and then look at the exemptions. And we look around the country and there's, a couple dozen states that are already impacted by these orders. You have exemptions for, in some cases, public construction. Some of the exemptions include housing, even mixed use, to promote that and not slow that process down. But a lot of them do bar commercial construction. There are exemptions for mothballing projects, so that while you have to shelter at home, contractors can go out and protect their work in place and mothball until given a further order. And even if you are exempt, for instance, even if you are in a jurisdiction that allows public construction, your exempt activities will be governed by the social distancing mandate of 6 feet, as I think we're all getting used to now. One other thing is, even if you're allowed to continue work, there are certain jurisdictions, and I gave you the example here of the city of Berkeley, who say you can keep working, but you're not going to get inspections. In their case, the only exception they're going to make is for income qualified affordable units. So you can imagine what that means. Even if you can continue working with social distancing, what happens when you can't get your next inspection? Clearly, our projects are going to be impacted and on the critical path. So that's really the biggest piece. I think the first piece to think about right now. And it's important to talk to folks that know your attorneys that can help you interpret what happens when you have orders that conflict. And we're dealing with this in the last 12 hours. We've got a County of LA order, which speaks one language. We've got the City of Los Angeles, which seemingly speaks a different language. And then we have the State of California, which comes out and issues a different edict. And so us as lawyers are trying to figure out what applies. Does the state trump the city? Or does the city, because of their particular mandate, trump the state? So lots of those conflict issues. And I'm sure you guys will have questions about that later. We can talk about particular sort of situations that we're dealing with here in the West Coast, but even other places, how you interpret those conflicts. I won't tell you that there's a bright line answer, as lawyers will say. This is a ambiguous area and it depends. But this is certainly an important area of whether or not you can even show up on the job tomorrow when you come into a shelter-in-place order. Our office is keeping track of various counties, the different orders. I know AGC has a similar chart that they are maintaining, which is good. Maybe for your projects, you should create a chart of what's happening in the counties where you are working, the cities where you are working. I gave you an example here of one of the exemptions that we're seeing. And we imagine that a lot of jurisdictions, regardless of where you are in the country, will use similar language about, even if you're ordered to shelter at home, that you're allowed to carry on essential infrastructure. The question is essential infrastructure broad, like this excerpt from Sacramento, which says construction? It doesn't have limitations on the type of construction with social distancing requirements. Or is it going to be more limited, where it's talking about construction of particular types of works, like, again, public works only, infrastructure works only, housing only. But the ones that we've seen, City of Los Angeles, Sacramento, again, digging in, you can see this is a part of a paragraph that's buried in the order, but it's important to parse out this language to understand what's going on. Number two is understanding your project. Knowing your status of your project as of now, being in tune with it, so that if you do get shut down, like we are here in California, in some respects, and again, we'll get into the governor's clarification last night about construction being able to carry forward, we think, throughout California. But if your project is shut down, it's important to know where you're at. What is the schedule? What does your cost accounting look like? What materials do you have in place? What is still offsite? What impacts are you going to suffer? And then you're thinking about, of course, if you have to demobilize from the project, what's your demob cost, your deceleration, your acceleration, if and when you are told, hey, we got to catch back up with the project schedule, what are your acceleration damages? Thinking about social distancing efficiency claims. I know we talked about that this morning. If workers have to be 6 feet apart at a minimum, how's that going to impact your efficiency on a project? Clearly it will. And again, the inability to get a permit potentially, or get an inspection for a particular trade or path of work is going to create other issues. So it's making sure you understand where you're at in the project, making sure you're comfortable with documentation, exploring any applicable insurance coverage. There is a wave of lawsuits that are just underway now with folks making claims under their business interruption policies, commercial, D&O. So think about it. Think about whether you have insurance coverage. Talk to your broker, talk to your attorney. It may be something where you want to move forward a claim and get a claim number and an adjuster and see where things go with the litigation that's breaking out around the country. And of course, it's all about documenting. I know a lot of us are used to handshake deals. We talk to our folks in the field. If you're a sub, you talk to the GC super. We do changes on a handshake or oral basis. That's sort of what we do. We've done for 30, 40 years. It's important more than ever to memorialize everything. Just because somebody says, don't worry, we'll take care of you. It's time to document what impacts you are suffering as a result of coronavirus, your demob issues, again, your acceleration issues, et cetera. And making sure that if you do have an oral conversation, that you memorialize that in writing, It can be an informal, friendly writing. It doesn't have to be a stern legalese sort of email, but something that memorializes the communication that's going on the project as projects are impacted. Okay, that's super important, is memorializing that stuff. Protecting your job rights. So this hopefully goes without saying. And some of you are sophisticated in this world, and others of you have never had to do a mechanic's lien before. Remember that you have various remedies depending on what state you're in. Every single state has a mechanic's lien remedy for private works. Some even mixed triple P sort of projects. 15 states have a stop payment notice remedy. Usually it may have a different name to it, but it's a construction, a lien on construction funds. So that may be available in your particular jurisdiction. Payment bonds, obviously federal, state, local, any public work is going to have a payment bond, usually $25,000 or more. But that's clearly something to think about. If you are a sub and you've never seen the payment bond and didn't know what existed, it's maybe time to start trying to ask around to get a copy of that payment bond, so you know if and when you need to make a claim that you have that at your disposal. For owners and some GCs that have subs on performance bonds, clearly knowing that those remedies might be there for you. And then there's other remedies that you have to think through. So in addition to the traditional ones like mechanics liens and stop notices, it's also thinking about, do you have particular ones in your state that might help you? I know in California, we have a remedy that's not used very often, but it's a statutory project security remedy where a general contractor can demand adequate assurances and the posting of job security by an owner. And this may be the perfect time to think about whether you invoke something like that. When you think, oh boy, my owner is going to have some financial issues here, or the lender's going to have financial issues, it may be time to do something like this, especially if you're in California, is to demand that the owner post a bond, a letter of credit, or some other security for you. There's lots of limitations and requirements for that, but that may be an important exercise to explore. In California, if the owner does not comply within 10 days, you are free to walk off regardless of the other circumstances. Or sorry, not walk off, but suspend your project. So again, thinking through all of your potential security rights, that's very important. So some special considerations I wanted to make sure that I address with you guys is making sure that you have the proper claim amounts with your lien or stop notice or bond rights, making sure that you're including the value of labor and materials furnished to the project. In most jurisdictions, you're not going to be able to include the items of like specially manufactured goods that are still sitting in your warehouse that have not yet been furnished to the job. I say that's most jurisdictions, not all jurisdictions. Some will let you do that. The federal Miller Act statutes, we believe, let you do that, make a claim for specially manufactured goods that are not yet incorporated into the project. But in most jurisdictions, you're going to have to show that your labor materials are in the project to be part of a proper claim. Making sure that you know in your jurisdiction whether you can include anything other than direct damages. Can you include indirect things, home office overhead, that sort of thing, lost profits? Generally not, but again, you got to check your jurisdiction and understand what the law is for wherever your project is. If you don't have all the relevant information, maybe you did a prelim haphazardly, or maybe you didn't do a prelim, it's time to make sure that you know who all the players are. Upstream, you know who the lender is, who the owner is, you know who the sureties are. If you need to move forward, do you have the information handy to help your provider, maybe it's Levelset, maybe it's your attorney, moving your claim forward. Making sure, of course, that you timely are enforcing your rights. Following all of the statutory prerequisites for timing, making sure that you don't wait too long, because deadlines around the country are very, very short, especially when it comes to mechanics liens. For instance, in California, you may have as little as 30 days from a completion of the job to record a mechanics lien. So things like that, being careful that you follow those deadlines. On the other hand, being careful that you don't record a premature lien. In some jurisdictions, if you record a lien and you're not done yet, your lien is invalid. In fact, we had that case in California, I think about 4 months ago now. It's an appellate case, it's good law, that dinged a subcontractor's mechanics lien because it wasn't done with the job yet. So you have to be careful on both ends, not recording too late and not recording too fast. And so you're going to have to think through how you're going to cease your activities. For instance, you may be issuing a deductive change order for the balance of your project, perhaps, in order to make your claims. That's something you're not going to take lightly. It's something that you're going to talk to your counsel about in detail to make sure that we don't want to be the ones breaching the contract. We want to make sure we document properly and we do whatever we need to do to be the folks that are stand ready, willing, and able to move the project forward. But we got to make sure that we protect ourselves in the event that we're running out of time. So a deductive change may be something to think about. And don't forget, in this day and age, we have lots of county recorder offices and courts that are closed. Last count, I know Levelset's doing a fantastic job at keeping track of the various county recorder offices that are impacted. You may not be able to get a lien done the same day. So don't wait till the last minute, because it may take time for you to mail in your mechanics lien or send it in. Levelset, fantastic resource for you to use to try to make sure you understand the timing and who's closed and who's open. So again, the lesson is don't wait too long. And then one other topic that I want to bring up that we don't talk a lot about in the good times, like we had 3 weeks ago. But it wasn't really, I think the last time was the last downturn. I mean, we've seen, since I've been practicing law, I think 3 downturns in the economy. We've never seen anything like this. Some of you have been around for a lot longer than that. But in my 20 years of practice, it wasn't, I think the last time was about 10 years ago when we had our downturn and we had projects that were being suspended, mothballed. And what that means in a lot of jurisdictions is if you mothball a project for a certain amount of time, that can equal a completion. So a cessation of labor for an extended period of time, it could be 30 days, it could be 60 days in your jurisdiction, that equals a completion. So I cannot underscore how important that is. Don't just be thinking, well, my project is still, God, the roof is just topped off right now. I barely have a roof on it, but we're not done with windows and we're not done with doors. We're not done with finishes. So clearly I've got time to record my lien or enforce my rights. If the project is mothballed for a particular amount of time, in California, that could be as little as 30 days. If the owner sends out a notice of cessation of labor, that equals a completion. And that gives you a very limited amount of time to go ahead and enforce your rights. Okay, so it's very important to make sure that you understand what that cessation of labor rule is in your jurisdiction, because if you have it and it deems a completion, you better get your lien down or bond claim notice enforced right away. Otherwise, you've lost it. And when you come back to the project, it's all about doing a brand new prelim and a brand new, it's considered a new project if your initial project is suspended for that requisite amount of time. Okay, so be very careful in your jurisdiction. An example, I know this is a screenshot of Levelset's county by county list of county recorders offices and clerks offices that are being impacted around the country, and they're adding to it on a daily basis. So I encourage you to check out the Levelset page. I want to move quickly. I know we're getting close to the 30 minutes here. I wanted to just move into the key contractual provisions. Now, everybody's talking about force majeure, and I know a lot of you know what that is. But remember that the key contractual provisions here are not limited to force majeure. They're much broader than that. We're going to talk about force majeure in a minute because it is important. But there's lots of other provisions in your contract documents which are going to dictate what your rights, duties, and responsibilities are going forward to protect yourself. For instance, notice provisions. What are the notice provisions of your contract? When do you have to give notice of a force majeure or an impact, a delay? How quickly do you have to do it? Who does it go to? What method of service does it go by? Your change order provisions clearly are going to be important in this sort of situation as you negotiate changes in time and dollars. Limitations of liability clauses, clearly going to be a very important provision for suppliers and contractors moving forward. What are the termination provisions? For cause, for convenience, understanding what those look like. And then default provisions, completion of work by others provisions. I mean, those all are parts of most industry contracts, and they all play a part in understanding what your rights, duties, and responsibilities are. So let me get into force majeure, because again, I know most of you have heard this term, and this is the one that everyone's hanging on, and it is important. We typically kind of describe it as things, causes, or events that are unforeseeable, unavoidable, or beyond the party's reasonable control. And the force majeure clause will act as a potential defense to breach of contract claims. And so it's an important thing to consider. Now, the things you need to think about of how your force majeure clause is going to play out for you starts with what state you're in. Are you in a civil law jurisdiction, or are you in a common law jurisdiction? Civil law implies force majeure in its contracts. In other words, the contract can be silent about it, and civil law will jump in. And for those of you that are in states that follow a civil law system, just like the duty of good faith and fair dealing, you will have a force majeure applicability. Common law systems, it's not that way. If you don't have force majeure, you don't have force majeure. Now we'll talk about in a minute in the sale of goods for you suppliers out there, or you purchasers of materials. There is a uniform commercial code provision which applies in all 50 states about force majeure for sale of goods. But for purposes of construction performance contracts, if you don't have force majeure in your contract, it's not going to be implied. Okay. There may be other doctrines to think about, like impossibility or impracticability. Those doctrines, legal doctrines, exist in various states, and the state's common law will dictate whether or not that is a plausible defense for you. Secondly, and of course, probably the most important thing is what does your force majeure clause say? What does it lay out? Sometimes, but not often, the force majeure clause will actually refer to a pandemic or epidemic. And so the question a lot of times is, does my contract, is it going to protect me in this particular force majeure world of coronavirus? So if you look at some of the most popular industry contracts like the AIA, you'll notice that in 831, we have a little bit of liberality, a catch-all clause, if you will. It describes, fire, delays, weather, etc. But then it has a catch-all of other causes beyond the contractor's control. So that is a fairly broad force majeure provision. And it does contemplate a extension of time and potentially additional money. So a lot of times in your AIA contract, if it's a GC using it, they will strike 8.3.2 or 8.3.3 or modify it a bit. But under the default provisions, at least of the 2017 form, you will be able to get additional time as long as you comply with the notice requirements, and potentially the recovery of delay damages, as long as, again, you follow the provisions of your contract. Consensus docs does specifically refer to epidemics and unavoidable circumstances. So that's a form contract that probably would kick in, the force majeure provision would kick in for consensus docs. And the FARs also refer specifically to epidemics. And again, the important part here is we're not going to go through, notice and change order provisions and termination provisions. I know most of you have read those and know what they are. But there may be other sorts of clauses that will kick in as well that sort of support the force majeure issue or defense. For instance, 10.4 of the AIA form contract talks about emergencies. When you have declarations of emergencies like we have had at the city, state, and county and federal level, this may kick in 10.4 to further support your force majeure issue and a related sort of argument. So that's why an exhaustive look at your contract from beginning to end is super important. And of course, price escalation clause provisions. Again, this is the one that we thought was going to be front and center a few weeks ago, and it's gotten much broader than that. But your price escalation clause will be important, not just with tariffs, but of course now with coronavirus issues. For suppliers, so I know there's a few suppliers out here on this broadcast. So this is a somewhat more complicated issue and area. So for the subs that buy the supplies, and for the suppliers that sell, and even for the suppliers that purchase and are traders, and sort of in the middle, those are the ones that are typically at most risk here. Because while there may be a force majeure clause with its manufacturer or its original supplier in China, it may not have the reciprocal force majeure provision upstream with the person that it's selling to, the end user here. So that obviously is an issue that's popping up, and we're seeing that now on almost a daily basis, where someone will call and say, oh my gosh, I have a force majeure provision, my Chinese manufacturer has invoked it, but I don't have a force majeure provision upstream with my guy, what do I do? If you haven't specified materials to the end user, they don't know the specified source, that could be an issue. And so again, without going through a whole battle of the forms analysis, which would be a 3-hour class, it's important to know that your contract as a supplier doesn't just consist of a credit agreement with terms and conditions, right? You may have a master supply agreement. And in that case, this provision, the force majeure provision, might be much more readily available. However, if you're doing business on a purchase order and an invoice basis, you give a quote, you get a purchase order, you do an invoice. Maybe there's a sales order confirmation in between. What are the rights, duties, and remedies? And it depends. It depends on what your terms and conditions say. It depends on what your customer's terms and conditions say. It depends what's on the internet and online terms and conditions. I will say, and I'm not being flippant about how wonderful terms and conditions of sale are. They're great. They are important. You should have them in every credit agreement. But when you move forward in a relationship, oftentimes you have changed the underlying terms and conditions with new purchase orders and invoices that are fulfilled down the road. And so what will often happen is you'll have what we call for us UCC geeks, and I teach business law in the UCC at a university. So I geek out about this provision, but we have what's called a knockout provision, where the terms and conditions would cancel each other out of the purchase order and the invoice, and you'd be stuck with whatever the UCC provides. And the UCC is usually buyer friendly. It's very buyer friendly. And there is a very particularly important section of the UCC called 2615 or 2615, which does have a broad force majeure sort of protection. It talks about commercial impracticability, which is good. Compliance and good faith with any applicable governmental regulation or order. Obviously, we've got lots of those here. So for you suppliers that get in a battle of the form situation, you may be protected. But again, I'm not trying to oversell the expertise here of construction lawyers, but it's imperative that you talk to not just an attorney, but a construction attorney in your jurisdiction. We always will recommend the ABA Forum on Construction Law attorneys. Again, a lot of them who are members of Levelset because of their particular expertise and their knowledge of how this all works, to help you understand what terms are going to control here and what your obligations are and what you're liable for and what you're not liable for. Okay, so that's all very important stuff. So let me I'll take one step back here before we start taking questions. So the force majeure provision, don't be mistaken. It doesn't itself let you walk away, right? There's going to be other things that follow on. There's going to be other language that's going to require you to give notice of the force majeure provision. Maybe in some contracts, submit a mitigation plan, maybe within 10, 15, 20 days. So you may have an obligation on you as soon as you identify the force majeure issue to document it, and then maybe show your customer that you're doing everything you can to try to mitigate that issue. Making sure you document, again, document, taking reasonable steps. And look, a lot of this is not, a lot of this is legal, but a lot of this is just human stuff. It's being able to call and talk to your customer, the owner, the GC, and trying to work out together what reasonable steps you guys can take together to mitigate the losses, what your expectation is for the future, and try to work this out on a human business level, not just on a legal level. So monitor the situation. Keep on track of those orders that are coming out on a daily basis in your jurisdiction. Review your contract documents with your counsel. Keep and maintain detailed records. Review your insurance coverage, and take steps to mitigate and explore whatever else you can do to try to satisfy your contractual obligations. We have some resources here, obviously some stuff just from the CDC and Johns Hopkins, but also AGC is doing a fantastic job of staying on top of things and advocating for the construction industry and helping to interpret what all these orders mean. And Levelset doing a fantastic job. They have a survival kit for construction businesses on its website, and it has an updated blog and Q's and A's, and it's all good stuff. So I encourage you all to stay up to date with this stuff, continue to do more webinars and seminars. We'll keep doing them. We'll be around to answer questions. Stay healthy, be safe, and we'll take some questions.
Chris, I see there's a question that's talking specifically about lien rights deadlines and the effect of closures of courts. The question says specifically, but I guess the same thing would apply to county recorder's offices, potentially a business that can no longer receive mail for notices. What do these closures of either governmental offices or businesses themselves, how's that going to affect people trying to do what they're supposed to do in maintaining their security rights on a project? How do they go about that? What's going to be the question here?
Yeah, and here's my lawyer answer. It depends. And I know it's not what people want to hear. This is unprecedented, uncharted territory for all of us. I will say, however, there's a couple of takeaways for sure with that question. One is, if you are contemplating you're going to need to record a mechanics lien because your project is suspended for an extended period of time, or you're terminated, or you're going to need to walk off because you can't make payroll, and you're going to need to try to salvage your situation, whatever it is, make sure you get your mechanics lien recorded as soon as possible because it may be delayed. And we don't know yet what the jurisdictions are going to do as far as granting leniency. They may not. Likewise, for lawsuits, I would say it's important for you to turn over your cases to your attorneys as soon as possible, because they may not be able to file a lawsuit the next day for you to foreclose on the mechanics lien. I mean, we ran into that yesterday where courts are like, hey, sorry, it's not going to happen today. So it's very important to turn over stuff sooner rather than later. Don't wait till the last few days on a foreclosure deadline to move those things forward.
I'd like to jump in really quick as well. I think that's absolutely the right information that Chris is giving from a perspective here of somebody who has gone through not a similar event, but a similar event in terms of closures with Katrina, when we had to try to file stuff down here in Louisiana in the aftermath of that type of a disaster. Like, the advice is absolutely perfect, and that you want to stay ahead of everything and get everything done as quickly as you can and not wait till the end, because you don't know what's going to happen. But it's not necessarily a doomsday scenario if something comes up where potentially the courts close down completely. Sometimes there are provisions where the deadline is told so that you don't lose your rights for exactly one of the reasons that he was talking about contractually, of circumstances completely beyond anybody's control. But the real takeaway is to be proactive and try to avoid the situation where you're going to be in a situation like that to begin with.
Yeah, Richard, Sarah and I were talking this morning about, for instance, in a lot of states, you have an obligation to serve a notice of intent or your mechanics lien before you record it or after. And how do you do that if businesses are shut down? I know, like in our building will not accept FedExes or overnight deliveries or anything like that. So it's being careful and mindful of the method that you're going to use to make sure that you've complied with the statute as best you can. I know in California, again, the law says that even if a certified mail is refused, that could still count as good service. So it really depends on your jurisdiction, and again, talking with your counsel to make sure that you're doing the best you can to try to protect yourself. Sarah, Richard, am I on, or you want to add to that?
Yeah, this is Richard. I would just, to put a final point on that, most jurisdictions, as long as the lien claimant has taken the reasonable steps to comply with the statute, I would suspect that a court wouldn't, as an affirmative defense, reject the lien because the building was closed or the business was closed. So as long as you take your reasonable steps, and then also in terms of the courts, right, there must be an equitable tolling if the courts are closed and you cannot accept filing. In some jurisdictions, remember, they will accept filing electronically, and if that's the case, that's what you also want to take a look at, either you as a contractor or a supplier, or your
So if I might, Nate, so I have a text message here from a client in Arizona. I'm not sure, they're not using the webinar chat here, but and this is going to be a topic that Richard and Sarah, I'm sure, will love to jump in on. We've been talking about this for the last 8-10 hours ad nauseum. We were all up super late last night trying to help our clients with this issue, which is in Arizona, we're concerned that they're going to follow suit as in California, where you're going to have conflicting state and county orders. What do you do in the event? Which has precedence? So what does the city of Scottsdale, the county of Maricopa, or the state of Arizona, if they issue separate and conflicting orders, what do we recommend they do, just like we're trying to figure out here in California?
Well, conflicting orders is kind of the rule right now. So everybody's going to have to try to balance what is being heard. But what we've been telling our clients now is, look at what the state is issuing and, move forward. Look for guidance from the project owner or the contractor if you aren't the prime, and assume that you can keep working, because there are a lot of exemptions for construction, whether they be broad or narrow. So go to work, maintain social distancing at your job site and certainly at your offices, but look to the owners and get written directives from the owners as to what should be done, so that if they're shutting things down, you need to know that you have to do all of those notice issues. Again, document. You have to make sure that all of this is going on in writing, both upstream and downstream.
Another great question from Melanie, who asks, this is a great question. So construction projects can continue with social distancing, but how about our business offices, which we think should be shut down? Does it apply?
But we just had that happen. Again, we'll focus on California and in Nevada. So what we had indicated to our clients, told our clients, that you have to have a home office in order to support the site, the crews on site. They're not mutually exclusive. So you have to have the home office. So therefore, we believe that the home office can be operational, and people should show up and support their site crews. But having said that, number one, it should be closed to the public. No public meetings. You're not going to meet a new potential client or do any of those types of things. So you close the office. And number two, you post a sign that it is closed to the public. But folks can, from the contractor or the owner, maintain the office. Also, as Sarah just said, you have to practice social distancing. That is very important. And you have to instruct the client that way. And number three, obviously, if someone's sick, they should not show up. And then finally, if you do have a staff person who can work remotely and efficiently, we recommend that they do that.
I see another question here with respect to notice of intents, whether that can be done over email and whether that's valid. I can jump in for a little bit at the start and say, a notice of intent is not required in every state. So the first answer to the question is, if you're in a state where you're sending a notice of intent to lien as kind of a demand letter with the lien power behind it, absolutely, you can send it any way you want to, if it's not a prerequisite to filing the valid lien itself. You can find out whether that's the case by talking to your attorney, by looking on the resources that we make available at Levelset. But if it is a requirement to a future lien claim, then there are methods set out by which that notice has to be provided in the state statutes. And you can either use a service like Levelset or your attorney or some other lien provider who will be compliant with that. But it's not often that email is accepted as a specifically delineated statutory form of delivery for a notice of intent to be valid. There are exceptions like Utah and Iowa use an entirely online electronic system for notices, so that will be an electronic version. I know North Carolina, I believe, contemplates electronic delivery of notices with some sort of receipt confirmation, but it really depends on your state. Again, that's the lawyer answer that nobody really likes to hear, but it really depends.
I see another question from Mr. Eaton in our chat window that asks about notarization. It's a great question. I actually thought about that this morning. is how do you notarize documents? I mean, I think it can still be done within the confines of social distancing. It also depends on your jurisdiction and what the shutdown order looks like. You know, I think a notary could still stand 6 feet away and probably notarize documents. There are, you know, essential services that are going to be open. The FedEx office is going to be open. The post office is going to be open. And so I imagine you're going to have notaries available a lot of times in those places that will be available for these sorts of things. But it definitely does present a challenge, no doubt.
And it's another reason to make sure that you're planning ahead, because it's just one more stumbling block that might take you more time to get done than you think would normally take.
Couldn't agree with that.
I know we've focused really on, you know, construction, obviously here. Remember, there's so many other legal implications. You know, with our employment department, we have at Gibbs Giddin talking about all of the issues that come along with what you need to do when somebody on the job shows up sick. Maybe it's your employee, maybe it's another trades employee. What are your employees' rights? What do you have to do as a company to protect your employee, if anything? There's lots of things, employment issues. So clearly, there's lots of things to think about as we try to figure out how we move forward from this. And it's important to also have not just your construction counsel, your employment counsel, but everybody on board to help you get through this. Any other questions? I know there's some questions about, yes, we will get the presentation. I think Levelset will circulate the materials. Happy to share those.
Great. I don't see any other questions coming through right now, but just to reiterate, if you have more questions, there is an expert center available on Levelset's website where construction attorneys and other experts, but even Chris is on there, I'm on there, a bunch of other construction attorneys are on there. You can ask a question, you can get information that way. Also, we have reached out to a handful of construction attorneys who have said that they are willing to talk to people on short consultations for free to help people talk through some of the issues that have arisen due to the coronavirus and the implications that has for their business and construction. So that's another opportunity that people have to get questions answered. And like Chris said, we're going to continue to be doing webinars and making information available to people to try to help out as much as we can. And I really want to thank Chris and Sarah and Richard for taking their time and giving their expertise to this. I know everybody has a lot of questions. It's a difficult time. We don't really know what's going on, even let alone what's going to happen. So it's really great of them to share that expertise. And thank you all for joining us.